Assalamualaikum to our lecturer and my fellow friends. Our group will present about industrial relation current issues. For the first issues is top 3 row NADIA ADILA, NASRULHAQ Rizmi and NURUL ASNA. And the other 3 bottom issue on the second is PUTRI AMEERA, NASHVIN and ALIA AMEERA.
Hello and hi everyone. Today I'm going to present about issue 1, court affirm HRM659 million award to ex-COO for constructive dismissal. First of all, my name is NADIA binti MOHAMAD NASIR and I will present about the identified issue. In May 2019, Industry Court Chairman Frederick Indran Nicholas awarded compensation to Tengku Hasmadi who left KTB in April 2015 after the chairman's son, Muhammad Haris Muhammad Nazmi, took over half his job function. Haris, 27 years old, had not even completed his study at that time. After return from leave, he was taken aback and received memorandum on 3rd March that Haris was to be appointed the company's head of group support services. Tengku Hasmadi told Nazmi this was serious breach of his employment contract and calculated to humiliate him and lost respect among his subordinates. In judgment, Nicholas said he found Tengku Hasmadi succeed in establishing a breach in the relationship of mutual trust and confidence between employer and employee. Then Nicholas said this is a dismissal in the instant case, notwithstanding that the company had not literally dismissed the claimant, but rather than forced him to leave his employment by their repudiatory conduct. He added that Tengku Hasmadi, by tendering his resignation, has acted decisively. He had protested against the company's breach. So, I pass to my friend to proceed this case study.
Thank you, Nadia. And I'm NASRULHAQ Rizmi will present to you about the statutory law and remedies of law in the current issues. The first one is Industrial Relation Act 1967 Section 20. Representation on the constructive dismissal is an employee who feels that he has been unfairly dismissed without just cause or excuse by his employer may lodge a representation to the Director General of Industrial Relations within 60 days from the date of his termination. From there, even something like publicly harassing or humiliating an employee can give rise to the constructive dismissal. In the article said, the claimant told Nazmi, which is CEO of the KTB, this was a serious breach of his employment contract and calculated to humiliate him and lose respect among his subordinates. The second one is Industrial Relations Act 1967, Section 33B, which is appealing against industrial court decision. This is enshrined through Section 33B of Industrial Relations Act 1967, which states that an award, decision or order of the industrial court is final and conclusive and shall not be challenged, appealed against, reviewed, quashed or called into question in any court. But Consortium Transnational Berhad, which is KTB, is dealt with High Court decision. Remedies of law on the Industrial Relations Act 1967 Section 20. In the event that an employee is constructively dismissed by their employer, he will have 60 days to voice his griefs by making a representation to the Director General. The court can make an award if there are valid cases that certify the court. The award is depending on the fact of each case. The second one, in order to remedialize, is reinstate to the former employment or compensation in lieu of reinstate and backwatch. What like in article said, High Court ordered a payment of 8,505 as a compensation in lieu of reinstated and another 1,637,010 as a back wage. Thank you. And then we proceed to ASNA.
Compare and contrast the legal issue with the case. Number 1. Constructive dismissal. Based on Employment Act 1955, Section 14, Subsection 1, an employer may, on the ground of misconduct inconsistent with the fulfillment of the express or implied conditions of his service, dismiss without notice the employee. In this case, the claimant, Tengku Hasmadi, who had been with KTB for 12 years, said he was solely responsible for the group's operations and support services covering about 3,000 employees. He was taken aback when he returned from leave and received a memorandum on March 3rd, 2015 that the chairman's son, Muhammad Faris Muhammad Nazmi, 27 years old, who had not even completed his studies at that time, took over half his job functions and was to be appointed the company's head of group support services. He then wrote a letter to the company's chairman, Muhammad Nazmi Muhammad Saleh, that he considered himself constructively dismissed. However, the claimant is proven not guilty of any misconduct, as he is rather forced to leave his employment and not literally dismissed. The second one, representations on dismissals. In terms of his dismissal, the claimant then wrote a letter to the company's chairman, Muhammad Nazmi Muhammad Saleh, that he considered himself constructively dismissed. The claimant told the chairman this was a serious breach of his employment contract and calculated to humiliate him and lost respect among his subordinates. The claimant had succeeded in establishing a breach in the relationship of mutual trust and confidence between employer and employee. According to Industrial Relations Act 1967, Section 20, where a workman, irrespective of whether he is a member of a trade union, of workmen or otherwise, considers that he has been dismissed without just cause or excused by his employer, he may make representations in writing to the Director General to be reinstated in his former employment. The representations may be filed at the office of the Director General nearest to the place of employment from which the workman was dismissed. The third one, High Court decisions. Based on Industrial Relations Act 1967, Section 33, Subsection 1, if any questions arises as to the interpretation of any award or collective agreement taken cognizance of by the court, the minister may refer the questions, or any party bound by the award or agreement may apply to the court for a decision on the questions. As for this case, the company failed in its judicial review to set aside an industrial court award that awarded Rm 2.45 million in compensation to be paid to the claimant for constructive dismissal. High Court Judge Mariana Yahya said the industrial court did not commit any error in making the award for the claimant, as she mentioned there was no illegality and irrationality when the tribunal made its finding, which is why the award is upheld. She then ordered the company to pay another Rm 5,000 ringgit in cost to the claimant.
Assalamualaikum warahmatullahi wabarakatuh. My name is Putri AMEERA binti NAZARUDIN, and now I'm going to present on the next issue, which is issue number 2, the ex-leader of NUFAM, National Union of Flight Attendants Malaysia, Ismail Nasaruddin, who wins 210,000 ringgit Malaysia for his unfair dismissal. The facts of the issues are, Ismail Nasaruddin is a flight steward with Malaysian Airlines since May 12, 1989. On November 8, 2013, it was brought to the company's attention that the Sun newspaper was carrying an article on the National Union of Flight Attendants Malaysia's call for resignation of the company's chief executive officer. The said published article referred to an interview of the claimant conducted with Sunbees, whereby the said article also referred to a press statement issued by NUFAM. The article also raised various other allegations against his employer. At the material time, the claimant was the president of NUFAM and a member of its executive committee. Consequently, the company issued a letter of suspension dated November 8, 2013 to the claimant, suspending his services pending further investigations. So, there are several identified issues from this case. Firstly, there was no dispute as to the fact for Ismail Nasaruddin dismissals. the court has to consider whether the charges against him have been proven. If so, the court must evaluate the charges made on him, whether those charges are serious enough to the extent to cause an excuse to warrant the dismissal of Ismail Nazaruddin, the work made on him by Malaysian Airlines. Next, Ismail Nazaruddin argued that he was not in a breach of express and implied terms. His condition of employment is under the circumstances, considering he had acted in his capacity as a union officer, which is, he was carrying out his union duties as the president of NUFAM. He then claimed that must discriminate him for doing such act. This is because there are no action taken on the Malaysian Airline System Employees Union Peninsular Malaysian Union official who had also made praise statements calling for, amongst others, on the removal of the Chief Executive Officer of MAS. Last but not least, MAS' stance was that the role of Ismail Nazaruddin is as a member and a president of NUFAM, in which was subject and secondary to his underlying fiduciary duty to MAS as his employer, meaning that MAS claim any act performed by Ismail Nazaruddin despite his role and position in the company, it was subjected to the underlying fiduciary duty to MAS as his employer. So, although it was Ismail Nazaruddin's right to partake in union activities, he was not immune from disciplinary action when he had breached his express and implied duties to MAS as an employee, in accordance with the claim made by MAS.
According to Section 2 of Industrial Relations Act 1967, an employee is an individual who is employed by the employer and receives wages and reward for a reason of the work performed. These employees include employees from various types of field and job as well as rank in the public and private sectors, whether executive and non-executive, such as accountants, executive tenaga nasional berhad, junior general assistant, and so on. For another law that applicable to this issue is under Section 20 of Industrial Relations Act 1967, an employee who is dismissed with notice may file the complaint at any time during his notice period, but not later than 16 days from the expire of his notice. Failure to file the complaint in time will result in the complaint being barred by limitation. Depending on the circumstances, the employee may have other resources in the civil court, but the damages and nature of remedies will be different. In this issue is successful claim under unfair dismissal, which is the industrial court will award either reinstatement and back wages or back wages and compensation in lieu of reinstatement. Back wages are meant to cover the period between the termination date and the award of industrial court, but they are capped at 24 months, which mean confirmed employees, and 12 months, which mean probationers. Compensation in lieu of reinstatement is usually awarded at the rate of 1 month for every year of service, but this is not a fixed formula and is still subject to discretion of the court. Further, any total monetary sum is also subject to discretionary deduction by the court after taking into account various mitigation factors such as conduct of employee and post-dismissal earning. The monetary award given is meant to cover all losses relating to the termination, and employees cannot claim for additional damages for things like loss of future earnings, loss of reputation, or mental and emotional stress.
For the first issue is interfering employee to get active in trade union activity by the employer. Based on Section 4, Subsection 1 Industrial Relations Act IRA 1967, it is the act of breaching the law if employer restrain any of the employee who are the member of the trade union to get active in the trade union activity. In this case, Ismail Nazaruddin is the president for the trade union, and among his duty are manage employer and union member relation. helping maintain order, leading meeting, processing grievance, organising new member and overseeing the rest of the labour union officer. By giving statement to the press about the issue happened in Malaysia Airlines is not an unlawful behaviour because it is the doing by the role as the trade union president. For the second issue is discrimination of employer toward trade union member. Based on Section 5, Subsection 1, Subsection C of IRA 1967, the employer is strictly prohibited from discriminating the trade union member in terms of promotion or any other condition of employment or even in terms of working condition. On 3 August 2003, Ismail Nazaruddin was demoted from chief steward to leading steward for making statement pertaining his employee to the media. On that moment, he is not yet appointed as the president for the National Union of Flight Attendants Malaysia NUFAN. He is a member of the union, and this enabled him to act as trade union member where he has to fight for the trade union right. By demoted him because giving the statement to the media regarding this internal issue is one of the unethical way of doing a job as an employer based on Section 5, Subsection 1, Subsection C of IRA 1967. For the third issue is dismissal of the trade union member. Refer to Section 5, Subsection 1, Subsection C and Section 59, Subsection 1, Subsection D, Subsection 2 of IRA 1967. It is offence to dismiss a trade union member if he participates to the activity of the trade union. It is also unlawful for the employer to dismiss an employee if he is one of the trade union member which the objective of the union is to improve the working condition. In this case, Ismail Nazaruddin is voicing out his opinion to the media to argue the National Carrier CEO Ahmad Jahari Yahya to resign. For the fourth issue is right of the trade union member after being dismissed by the employer. In terms of his dismissal, Ismail Nazaruddin has the right as a trade union member to make representation in writing to the Director General to be retained in the former employment. The representation may be filed at the office of the Director General nearest to the place of employment from which the workman was dismissed. Section 20, Subsection 1 of IRA 1967. In other words, there is no just cause for the employer to dismiss him. Ismail Nazaruddin has sent the letter to the respective party and person, and that is the starting point where the case is being brought so the industry court. The last issue is domestic inquiry. Based on Section 14, Subsection 1 Employment Act 1955, an employer has to make a domestic inquiry if the employee has been accused by a misconduct behaviour resulting in the dismissal from his employment. In the instant case, Ismail Nazaruddin claimed that his employer had failed to conduct a domestic inquiry before dismissing him from service contrary to the procedure established under the company book of discipline. That's all from us. Thank you.